Okay.
Yeah.
Test, test, test.
Oh, I don't get to see you very much.
They don't touch you.
Jess, how you doing? Good. All right, court will call 20 CR 58 People versus LETECIA Stauch. Record should reflect the jury has returned to the courtroom. When we took our break this morning, I said that when we resume, we would be restarting with questioning by the attorneys. That's where we start at this point in time. Prosecution.
Somehow they always make the prosecution go first right after lunch, and everybody's tired, right? Let's get some ground rules, talk about those before I get into the meat and potatoes discussion. This is a safe space. Everything that we talk about here is to determine and help us figure out who would be good jurors for this case. It's not a personal condemnation at all if you don't make it onto this jury. It just means that this particular case is maybe not the best case for you. But we're confident, based on the way that we've seen the jury system work, that we can get fair, unbiased jurors through this process of this question. The way that that works the best, though, is hearing from all of you. So it doesn't do us any good if it's just me talking the whole time. So I'm going to be making sure I touch as many of you as I can with questions, not physically, but with questions. You got my joke. And really hoping to get some really good discussion going on some of these different topics. So with that in mind, does everybody agree with that? That if you have a thought, please raise your hand. You don't say your juror number. I'll try to say your juror number. Again, that part's actually awkward for us. We're usually used to using names when we do this, using your last name. But trying really hard to be very cognizant of the concerns as it relates to this particular case, just using juror numbers. So if I don't say it, please help me remember to say your juror number. So with that in mind, I would like to have somebody give us what comes into their head when they hear me talk about what Lady Justice looks like. What do you think about when you think of Lady Justice? Okay, so someone over here, I believe number 17. Well, seat number. Yeah, I think you said. Yeah, so that's the other thing we like to do is confuse the heck out of all of you. Pull you out of your comfortable lives and make you sit in cramped corners and get to know your neighbors really well. 17, you said scales, I believe. What do the scales mean to you? Equal rights?
Justice.
Okay. Equal justice? Okay. Any other thoughts about Lady Justice? Okay. We have, I believe, number 33. Thank you. Yep.
I remember it, she's wearing a blindfold.
Okay.
With her scales. So she's just balancing whatever's in her hand.
Okay. Sword also. Do you remember the sword? Okay. Now it's coming back to you. But it's interesting that you said the blindfold. What does that blindfold mean to you or to anybody else?
She's no respecter of persons. She's only one. What the evidence is.
You're saying it exactly right. And I'm going to add another wrinkle to that. What that blindfold represents is that the justice system should be fair and impartial, the themes that you're hitting on. The scales are to weigh out the facts in the law and determine whether somebody did something that, like we're saying, this defendant did something. And that blindfold represents what you all have to come into this process with, being fair and impartial so that we can have a due process right that every American is entitled to under the US Constitution. So does everybody here agree that you will be open-minded, listen to the facts, and then base any verdict that you come to in this case based on that kind of a mindset? If you agree with that, please raise your hand. There's some people that are not raising their hands, and I'm going to call on those folks. So number 13, you did not raise your hand.
Yes, there's just been so much coverage that you almost feel you got your mind already judgment determined.
Okay.
And I mean, your opening statement,
Yeah.
it was like, turn on the TV and watching the evening news. It's like,
Okay.
yeah,
Okay.
you know,
So let's talk about this concept, Mr. 13. The stuff that you see in the media, do you think that the media, and I'm not casting aspersions, but do you think the media reports all the facts?
no.
Do you think they report the facts accurately?
No.
Okay. And so with that in mind, do you think that you can set aside what you've heard in the media because it's not the full story? And in fact, it's not evidence in this case. Do you think you could set that aside?
Yeah. It'll be difficult, but you know, it's something you gotta do.
But you think you could do it? Okay. What about juror 14? I think you did not raise your hand either.
What you just stated about Lady Justice and being fair.
Yeah.
I have real strong negative feelings about the whole judicial system.
Okay.
I don't believe in it. I've known firsthand, I've seen a lot of unfairness and discrimination,
Okay.
and that goes from the judge to the DA to the law enforcement to everything.
Okay.
So I do have very bitter feelings about the whole judicial system. I think it's messed up and
Okay.
it needs a lot of work.
Okay. So let me ask you this then, with that experience in mind and the things that you just expressed, which are totally valid, you can have those opinions. Do you think that you can set that aside and judge this case based on what happened in this courtroom or not?
You know, to be honest, I'm just so bitter because what I've experienced through this court system, I really don't think so.
Okay. And so that's based on your own personal experiences? Okay. Thank you for saying that. Number 2, I think you also did not raise your hand when I was asking you. I missed it. I'm sorry. Oh, that's okay. So when I was asking about, can we all agree that we're going to be open-minded and be fair and unbiased in this process? Do you agree that you can do that? Yes. You do agree. Okay, thank you. Number 4, what about you, sir? No, yes, you do. Okay. And I believe you are an engineer in the Navy, is that right? Okay. You have to say yes or no, otherwise. she
Oh,
can't
yes.
get you down.
Yes, I am an engineer in the Navy.
And by the way, if anybody messes that up, I'll be the one that gets in trouble, not you guys. I've already given her permission to throw stuff like that. Does 1 + 1 always equal 2?
Yes.
Okay. What if there's a negative integer? Can that become 0? Okay. So is that kind of a way of thinking about, there could be 2 different perspectives about something that may seem obvious to people?
Yeah, absolutely.
And what are your thoughts about that? How do you think that might apply to what we're going to do here?
With-
No, you're gonna hear witnesses
Yep.
that come in and give you descriptions about what they saw, what they heard, what they did in this case. And then you might hear another witness, maybe from even the defense side, that comes in and says something totally opposite of that. How do you reconcile those things?
I think if it was 2 credible witnesses, they both raise their right hand and tell you 2 completely opposite things, I think they cancel each other out.
You think they cancel each other?
Yep.
Okay. Everybody hear what Mr. Number 4 said? That's so weird to say Mr. Number 4. Everybody hear what Mr. Number 4 said about that? Anybody have any disagreement with what he said? Not seeing any hands. What about number 6? How are you doing so far?
I mean, I feel like my previous statement may have been sufficient. Just in, given what I already know about this case and what is being defended. At the end of the day, I feel like my mind is made up. I don't believe that there's any evidence.
Okay. You haven't had any evidence yet, correct? Although what you heard in the media, which you talked about earlier. Again, you have to say yes or no.
Yes,
Okay. If you are on, let's assume that you're on the jury right now, and you haven't heard any evidence with what you have in your mind, how would you have to vote? Guilty or not guilty?
I don't know the answer. Given what has already been said by you earlier about what we're gonna see, what we're gonna be shown.
Okay, so here's what I'm getting at is that the prosecution, so as the district attorney and every DA in my office, that's a deputy DA, we have the burden of proof. If we don't prove a case, then you have to vote not guilty. So if, as you're sitting here today, you haven't heard any evidence. So if we said, okay, now you gotta give us a verdict, what would your verdict have to be under that guideline?
Prior to,
Okay, and so if we don't satisfy our burden of proof, so we don't give you enough evidence to prove that the defendant committed the crime that I talked about earlier, would you feel comfortable setting aside what you heard in the media and voting not guilty? You wouldn't? Okay. Does anybody agree with Mr. Number 6? Okay, I see a head nodding and you are number, I'm not sure what number you are actually. You're 40, okay. So you all spread out. a little. You were saying that he would have to say not guilty.
Just agreed.
Okay, and are you comfortable with that, holding us to our burden? We're gonna come back at the very end of this, after all the evidence has been presented, and we're going to say, we expect the jury to hold us to our burden. But if we have satisfied our burden, we're gonna ask for the jurors to find the defendant guilty. Are you comfortable with that process?
Yeah.
Okay. Part of what we have to do as prosecutors is present evidence. So every single bit of evidence that we're going to have the jury consider in this case is going to come from this witness stand up here. So people will get on the stand and they'll testify, they'll take an oath. You'll see pictures, you'll probably see videos, you might hear audio recordings, including some of those pictures are going to be some really horrible things. You're going to see a decomposed 11-year-old boy who has suffered horrific injuries. Do you think as you sit here, that you can do that. Look at those things and consider whether the defendant is guilty or not guilty, based on what we're presenting. And I see Mr. 55 is shaking your head. I think no. Correct? So tell me what's going through your mind. Okay. Okay. That's a different topic that I want to touch on. I'll tell you a story. Several years back, I was doing a different murder case prosecution. One of the people that was in this type of a group had previously worked in the coroner's office. But only worked there for a short amount of time. We're asking him questions about, could he do this job and see those types of pictures. And then he ends up on the jury and we get to the autopsy pictures and they can be shocking. I mean, if you're not used to seeing that kind of thing. And he immediately shot up out of the seat and had to run to the bathroom. Lost his coverage, basically. So that's the kind of thing that you're going to have to do if you end up on this jury. And so it's good that you let us know that. If you don't tell us those things, then it's going to be a difficulty for you, then we don't know it, right? And so when we go here to the front, 24, thank you.
I think I would personally have a problem like stomaching it. Normal circumstances, I might be able, but I have a problem already.
So I'll tell you another personal story about that. When I was in law school, we had at the school that I went to, the Defender Project. Whereas after your first year, during your second year of studies, you could do the Defender Project, and I did that. And I had young kids, they were 2 and 5, I think, at the time, 2 and 6. And one of the cases I got assigned to was a young child death case. And it was hard because it was personal. It made it seem personal. And so you're saying that might be difficult for you because of that personal connection? Anybody else feel similar to that? Yeah, let me get your number. Thank you, sir, 35.
Yeah, I kind of feel the same way because I have a friend.
How long ago was that?
About 10 years ago.
Was it here or somewhere else?
Something
Okay. You think with that experience in mind that you could work hard to set that aside and just judge this case based on the evidence in this case?
probably could, yeah.
Probably could, okay. And going back to you, number 24. If you're expressing some reservations about whether that would be something you could do or not, you think you can judge this case based on this evidence and put that personal side to the side and judge this case just on the evidence?
I don't think you would affect my judgment on the case. They just have to find it.
Okay. Any other thoughts on that before I move on? Yes, thank you. You said 30, 36? Yeah, 35 over there. Yeah. And that's a personal thing. You're already sort of answering your own thought as you're saying it, knowing that if you see something that's shocking to you, it's probably going to stay with you for a while. I can tell you the first murder scene that I went out to, and we brought the murder scene with the police officers. I still remember about that. Very good at things, smells, images. And so you have to work through them in your own personal way. There's no magic way to get past that. But it is a consideration you'll have to think about. How do you, how do you as a person in everyday life, because we do this every single day, we hear stories from people. And we're able to reconcile two different viewpoints, kind of like what I was talking about over here, two different viewpoints about a singular event. Maybe two people go to the same party, they have different experiences, they describe the party differently. Doesn't mean a party didn't happen, right? It's just their own different perspectives. How do you judge somebody's credibility in that scenario? '29. You've been quiet today. Okay. Have you ever had two friends tell you about something and then you listen to them, you think, oh, this guy is full of baloney, this guy's not? How did you do that?
You're 29. Can you speak up a little louder so that we can hear you better, please?
Yeah. So basically, he was saying that he would listen to both sides and try to figure out which one was telling more true things, basically. I'm paraphrasing. Is that a good paraphrase? Okay. Again, speak up. Here's a funny thing, and I know right where you are. You're a shy person, it seems like. In school, I'm still actually a very shy person. I used to really hate talking in front of people. And so when we had those assignments where we had to give a presentation to the class, I would hide in the back, slink down in my chair, get sweaty palms, not want to get called on. And then I'd finally get up there and I'd fumble my way through it. So of course I become a trial, right? So I know exactly where you're coming from, but to help us flesh out who's going to be good jurors for this case, we got to get into some of those topics. Okay, so my apologies for calling you out like that, but we just have to have those things happen. Yes, ma'am. And you are 37, I believe? Or are you going to be 35 too?
I was just gonna respond to the question. Of the teenagers. It's just the way it is. So
Are you able to work through that and figure out what happened?
yes, I mean, the thing is.
How do you determine somebody's intent, what they intended to do? Without getting into whether they said they intended to do something. You think of any experiences where you have to figure out somebody's intent? Okay. And you are, again, I believe, 17, thank you. You get a feeling? Okay, all right. So yes, ma'am. Not 35, 38. That whole row is now 35.
In my line of work, intent is, a lot about past.
I don't know what SMI is.
Seriously, mentally ill.
Okay,
So I use SMI for the state of Arizona. I see a lot of people that come in crisis.
okay. So let me try to see if I understand what you're saying, just so we're all on the same page. You look at their actions to see if they follow through with,
Before they even got to this point, what was their past history? Cut down habitually in the past, and now here they are in front of me. like a pre-batch and then they go.
So are you saying actions can sometimes be louder than words?
Yes.
Okay. Anybody agree with 38? Anybody disagree with 38? Number 19, you raised your hand really quick. And I asked you, right, did you take a break? You raised your hand really quick when I said anybody agree with what, actions speak louder than words. Why was it so quick? What was in your mind? Actions always speak louder than words. Okay. Anybody disagree with 19? Seeing no hands. So let's do this. This is gonna be a really silly example. Let's say that it's illegal to buy more than 1 pound of ground beef at the store and get it. And I go in the store and I buy my 1 pound of ground beef. And I go out to the car and then I come right back in and I buy another pound of ground beef. I do that like 4 or 5 times. Am I exhibiting an intent there? Number 21. What about, yeah, so what about that description tells you I knew that it was illegal? Okay, so. Again, is that an example of action speaking louder than words? Anybody disagree with that idea? 36.
The one. That was similar during COVID. Right? Let's be honest, right?
That might be an excuse. Anybody have thoughts on what 36 was saying? No?
I think it's right.
You don't think what's right?
Greedy.
Okay,
Because you're hurting someone else.
so you would convict me for buying too many pounds of ground beef under that scenario? And it's okay, the answer is yes. Jeff talked about recipes earlier, recipes to likening it to what we have to prove in a criminal case, the elements of a crime, and he used the Denver omelet idea. That's similar to what we do in criminal law, where a particular crime has elements that we have to prove. What we have to prove as prosecutors is only those elements beyond a reasonable doubt. All the side stuff, we don't have to prove. Who here thinks motive is one of those things we have to prove to achieve our burden of proof? Motive. Okay, and again, number 17. You think motive helps?
Sure.
Okay. If you're on this jury, do we have to prove motive to you to satisfy our burden of proof?
Everything else has to get there.
Okay, all right.
Mr. Allen,
Yes,
thought you had a hand.
Oh, okay.
for number 4.
Yeah, it's, I mean,
thank you.
you have to meet all the burden of the charge. If that's one of them, then you have to meet that. But,
Okay.
you know, you're just driving down the road and you took your eye off the wheel and you ran somebody over and killed them. There's no motive there. But you don't charge them with that. You know what I mean?
Yes,
So that's important. And that's an important piece of it.
it might be a good way of understanding why something happens, right, is what you're describing. And I think that's the human condition, that when we hear of something happening, we want to know why something happened. Does everybody agree with that? Does anybody disagree with that? As humans, we want to know why something happens. Here's a, maybe an eye-opening thing for everybody. Motive ain't one of those ingredients in the recipe for the crimes that we have charged in this case. We don't have to prove motive. It's not one of the elements, not one of the ingredients for that Denver omelet that Doug was talking about. Anybody have any thoughts on that? Anybody have any issues with it? Or does it make perfect sense to you? I'm gonna call on, I've been meaning to get to you number 34.
No, that's good to know, but that's not part, I think of what just. I was thinking back, I would go back to the. Oh, no, no. Why you can use something. It that will bounce around me.
You're good with that. Okay. And I think you were one of the people that had mentioned, I think you agreed with one of the other jurors earlier this morning about having heard some stuff about the case and then sort of wanted to retract what you'd put on your questionnaire.
Right, yeah, I didn't, just explain it. Sure, but hearing stuff in the news, I can. Put down. After going through the process, let's see what it. Illustration of.
Lady Justice.
Yes.
Yeah.
Really helps me with that. Why did it explain that?
So with your experiences in mind, having worked in that area, having seen some news, having put the things down that you did on your questionnaire, do you feel like you can be a fair and impartial juror in this case and just judge the charges against this defendant based on what happens here in this court?
No doubt.
You have no doubt that you could do it. Okay. Does anybody, we already heard from number 14, and I think number 13 as well, kind of feel the same way. Anybody else feel differently than what 34 just said? Anybody feel like they can't be fair and impartial during this case based on things that you might have heard or seen in the media? Okay, yep. Number 6 is raising your hand and based on the stuff we talked about earlier.
I would like to mention that I feel like I've learned more about this case in the few hours I've been in this room than from the media.
From what's happened here.
Yes.
Okay, so that gets to the concept that the judge mentioned earlier that the only people that can give us evidence in a case come from that stand. So we're not witnesses in the case. So myself and the other 2 attorneys from the prosecution and Mr. Tellini and Mr. Cook are also not witnesses. So the things we say is not actually evidence. What do you think about that? Does that change your opinion as to can't consider necessarily what we say as you weigh guilt or not guilt?
I understand that what has been presented this morning is not evidence, but it was said that what you had said was true. Before this being in here, there was very limited knowledge I had of this case. I knew a boy had died. I knew who the accused was. I knew he was found in Florida. Since then, I have learned that he was stabbed multiple times, defended himself, was shot, was beaten, was driven to another state to be disposed of, and all of that stuff. And then I was told that everything that you had said was true. And that the reason we're here is because they want to convince us that she was legally insane at the time of committing these acts that we've already been told happened and were true, without a shadow of a doubt that this boy is dead. I can't see myself looking at this any differently than the drunk driver killing family.
Okay.
Whether or not they remember it, they were sound-minded when they did it, it doesn't matter, they still did it.
Okay. So let me clear up one thing that you said as it relates to the law, what it says about this process. We have to prove that everything, all the elements for the charges that we've charged here, all the counts, we have to prove those elements beyond a reasonable doubt to whoever ends up on this jury. We also have to prove, or you could say disprove, prove that the defendant was sane at the time of committing those offenses. This table here, the defense table, doesn't have to prove anything to anybody. And that's based on our constitutional provisions that are unique to this United States. No other country in the world has those same provisions in the law or allows defendants to have the rights that they have here in the United States. Does everybody understand that as it relates to who has to prove things and who doesn't have to do anything? Does anybody think anything differently about that? That they think they want the defense to prove something to them? Not seeing any hands. Okay.
Yeah,
Yes.
this is probably the thing that I'm struggling with the most.
Okay.
So if everybody sitting there agrees that this happened, including the defense, but they have a defense, don't they, isn't that implied that they have to prove that she wasn't in sound mind when this happened?
So the answer is no, they don't have to prove a single thing. They raise the defense, it's called an affirmative defense. And then we have to disprove it. So let's use this as an example to talk about this particular point. If, say there's a bar fight where one guy punches somebody else at the bar, and it causes that person that gets punched to have a broken facial bone or something like that, that would be a felony offense. But maybe the person that threw the punch says, yeah, I threw that punch because the other guy pulled a gun on me, so I punched him before he could shoot me. So raising the affirmative defense of self-defense. So we would have to prove in that scenario, one, that the person that punched actually punched and caused that broken bone. But we also have to disprove that it was self-defense. Does that make sense? I heard it over here, so. Yeah. But does that make sense to you, number four?
It does make sense, but what I'm laying out is I'm just kind of struggling with this concept.
Yeah. And I think it's a reasonable concept to struggle with. If you haven't gone through this process before, it sounds odd that they don't have to do anything, right? They can just sit there. I know that they're not going to do this. They're really good trial attorneys, but they could sit here and not say a single word for the entirety of the case. And if we don't meet our burden, you have to say not guilty, even if they don't do anything. They don't have to prove a single thing.
But you've met your burden.
If we meet our burden, then you can vote guilty. If we haven't met our burden, we have to vote not guilty.
I guess what I'm getting at is if all the evidence points toward meeting your burden, then if the other side says nothing, why would anybody here vote the other way?
Okay. And really what you're saying is that you're assuming that we have met our burden in this hypothetical scenario.
Right.
And then you're absolutely right. If we've met our burden and the jury feels that we've met our burden, the right verdict would be to be not guilty if we've satisfied our burden. So you're hitting on exactly the right thing. It's just struggling, I think, in talking about these concepts that you don't have to deal with every day like we do. But you're talking about the law exactly the right way, just in not the way we talk about it. Does that make sense? And so I heard somebody back here say yes or uh-huh.
Sense of it's kind of, I've seen.
And you're 38.
So I've seen this, person on the solar, I've seen it, because I deal with that type of population. So I think you not. So I think that would be clear for him to.
You.
But I'm just talking.
Yeah,
Like,
yeah.
if we were together, that it is possible. Like, you know,
And so actually, we're going to jump into some of your back. I was going to do this anyway, but you're bringing it up now. So you have that history working with mental health patients,
Yes.
right? Would you agree or disagree that there's a wide spectrum of mental health? Lots of people with mental health are still sane,
oh, yes.
know what they're doing? That's a yes or no.
Oh, yes,
Yeah.
yes.
And can form intents,
Yeah.
intentional with their actions. And getting back to what you said earlier, their actions can speak louder than what they're saying with their mouth.
Yeah.
With your background in mind, do you think that this type of case would be good for you or not? Good for you? Okay.
I believe I know both of them. All studies for mental health, correction, in-person outpatient, excuse me, crisis. And I see both sides, I see people that. I know nothing about this case.
Perfect, sure.
Yeah, I was like, I know nothing. But just
Anybody hearing, 38, say that, have any opinions that they want to share? Oh, you had your hand up first. Okay, first. Anybody else? Back here, number 2, thank you.
Number 4 brought up the issue of, what do you have to prove? If the defense is not guilty because of insanity, who it has to address the sanity issue?
Okay,
Is that part of your element?
so that's something that we have to disprove. Yes, so we have to prove that she was sane at the time of the offense. So let's talk about that for a second, and I want to come back to 35, 36, 38. I'll come back to you in just a second. The insanity part only applies to at the time of the offense. Meaning that we have to prove that she was sane on January 27th, 2020. If she became insane later than that, that's not, has nothing to do with this case. If she was insane before that, but then got better, has nothing to do with this case. Does that make sense with what you're saying, sir?
But you have to address it,
We will have to address it, and we will address it.
because you said they could do nothing. If they do nothing and claim not guilty because of insanity, then there's no evidence.
That when they claim that, then we automatically have to do some things to disprove it, okay? I'll get to you in just a second, okay? What are your thoughts about what I just said? It's at the time of the offense, not other times, that matters.
typically in my. Trauma, severe trauma, that's what I mean, background, very important. That's gone crazy. That's right there. Unless there was something that triggered her.
Five minutes, Mr. Allen.
So they just, not that they can't, just seen some.
Okay.
Or
We are going to have doctors testifying on both sides of this case in all likelihood. And part of our jobs as prosecutors and part of their jobs as defense attorneys is to cross-examine those witnesses. You may see some of those witnesses get challenged pretty heavily, and maybe very strenuously and maybe animatedly even. What do you think about that? Do you think having maybe their doctor or our doctor really get raked across the coals, part of this fair process? Is everybody good with that? Watching that sort of thing happen? Yeah, okay. Number 73, way in the back. We know each other from political circle, right? Despite the fact that we know each other, you think you can set our a friendship aside and just judge this case based on the evidence that you might hear in this case? Mr. 66, you put down, I think, maybe some hardship because of work stuff and representing Teller County. You have to tell us whether you have the time to serve on this committee.
Other than that, I'm gonna call out the top
So what are you streaming here? Hello? I can't hear you.
I'm having some tech issues.